everybody. Good afternoon, everyone. I'm Haley Fuller, and I'm the president of the Tulane chapter of the Federalist Society. This is Avery Nolan. She's from the American Constitution Society, and it's our pleasure to welcome you to this important and timely discussion on the ethics of war. This is a topic that raises difficult questions about the intersection of morality, law, and national interest, questions that have only grown more complex in an age of transnational terrorism, shifting alliances, hybrid warfare, and a global legal order under strain. We're fortunate to be joined today by two distinguished experts whose professional and academic work offer us deep perspectives on ethical and legal principles, on how ethical and legal principles should govern the conduct of war. First, we are honored to welcome Charles Cully Stimson, a veteran of both military and civilian national security service. Mr. Stimson served for 30 years as a Navy JAG officer, during which he deployed with the Navy SEALs and served as force judge advocate during a key operation to East Africa in 2000. His legal expertise is grounded not just in theory, but in lived experience of wartime advising and command-level decision-making. From 2005 to 2007, he served as Deputy Assistant Secretary of Defense for Detainee Affairs, where he was responsible for U.S. policy on the detention of enemy combatants. In that role, he led the U.S. delegation to the United Nations Committee Against Torture in Geneva in 2006 to defend the United States' compliance with the Convention Against Torture, a moment that required the careful articulation of both legal reasoning and ethical justification under intense international scrutiny. Mr. Stimson is currently a senior legal fellow at the Heritage Foundation, where he created the chairs the National Security Law Working Group. His work there has focused on the law of armed conflict, counterterrorism, military commissions, and Guantanamo Bay. He has testified before both the House and Senate, authored influential reports and op-eds, and remains a key figure in the national debate over how to balance security, legality, and liberty in times of war. Joining him is Professor Frédéric Sourgens, the James McCullough Chair in Energy Law and Director of the Tulane Center for Energy Law. Professor Sourgens is an internationally recognized scholar whose work sits at the intersection of transnational legal theory, global governance, and ethical reasoning. His research often explores how legal authority is constructed and contested across borders, a central theme when we consider how modern warfare plays out under both domestic and international legal regimes. Of particular relevance to today's discussion is Professor Sourgens' work on international energy law and organizations like OPEC, where questions of sovereignty, power, and global coordination often echo and inform the challenges of conflict and coercion. His scholarship probes on how legal structures governing resources and markets can become entangled with questions of geopolitical conflict and how ethics plays a role not only in battlefield conduct, but in the larger systems of control and dependence that underlie modern power dynamics. Before joining Tulane, Professor Sourgens was a professor at Washburn University and served as editor-in-chief of the ICSID Review, Foreign Investment Law Journal, where he shaped discourse on international arbitration and transnational legal responsibility. Together, Mr. Stimson and Professor Sourgens bring a wealth of experience and scholarship that allows us to explore the ethics of war, not just from a doctrinal or policy perspective, but through a broader lens that includes operational realities, philosophical commitments, and the changing architecture of global power. With that, we invite you to listen, question, and deeply engage with the ideas presented. Please join me in welcoming our speakers, Mr. Charles Cully Stimson and Professor Frédéric Sourgens.
Okay, so our first question is kind of about population and land. So the question is, who is currently responsible to provide or assist with the environmental cleanup and restoration of areas ravaged by conflicts? And who do you think should be responsible?
To start on the legal side of that, it will depend a good bit about what law you're applying to that question and how you're looking at that particular conflict. So you will have different answers to that question in the context of international humanitarian law. You have different answers to that question as a matter of international human rights law. You have different answers to that question as a matter of general intervention. And part of what is going to be significant in that context is this a conflict in which force was permissibly exercised or not? In terms of who should, I think one of the things that is difficult on that front is that failed states serve nobody. And nothing is more dangerous for a state than to lose essential infrastructure and not get it back. So to a certain extent, rebuilding war-ravaged areas is something that is in everybody's interest to the extent it can be done right. It's something that is incredibly difficult to do right. And so I would say in terms of should one help rebuilding, and the answer is yes. Who should do so would depend on who's actually capable of doing that. To the extent that you have an aggressor who violated international law in commencing an armed conflict, there would be strong arguments to suggest that a party like that similarly would have responsibilities to rectify the situation for the civilian population.
First off, I want to thank ACS and FedSoc and Tulane Law School for inviting me, and the professor for joining me. I know he said he has to leave at 6, so I'll be quick on this question because I can't really improve on his answer here. But I would challenge all of you as we have this discussion today to divorce yourselves from the contemporary conflicts in the world that evince passion and think back into war generally. So I'm going to refer to World War II, or my father served World War I, and other conflicts around the world, because it's very easy to come up with the answer of your preference when you apply it to, say, the Palestinian issue or the war in Ukraine or things like that, because these are broad general principles. And the professor's right. In a lot of these questions, as they're written so far, the answer is it depends. And one of the things that I would add to his excellent response is, and if you don't, what is the enforcement mechanism? And oftentimes that leaves a bad taste in people's mouth, because at the end of the day, there are very few enforcement mechanisms under international law that can compel a state to take action after they've taken hostile actions in an armed conflict. I'll leave it with that.
Do current international laws provide enough protections for historically, religiously, or culturally significant sites that would be particularly vulnerable during wartime?
No. And I know but I mean, the reason that I say no is that while there is a correct legal answer to those questions, in that you have principles of distinction and proportionality and targeting decisions that would strongly suggest that one should stay away from precisely those sites. Good luck enforcing that, one. And then the other thing that one has to bear in mind is that to the extent that a militarily legitimate target places itself precisely in those places to create a shield for itself with those sites, you again change the calculus at that point. So the laws of war function to the extent everybody plays by them. To the extent that a party does not play by them, it becomes incredibly difficult to then figure out how it plays forward from there and see enforcement mechanism. How are you going to replace the irreplaceable to the extent that it has come into such a position?
I disagree with my good friend. I think the answer is yes, as the question is phrased, but it's honored in the breach. Because remember, the 4 principles under the law of war are necessity, distinction, proportionality. That doesn't mean body for body. It's a different concept than most people agree, think it is. And then the doctrine of humanity. And so the rules are relatively clear if you're going to follow them, especially if you're going to take the advice of people like JAGs and other people who school warfighters in the law of armed conflict and what are legitimate and illegitimate targets. But we've seen, and you and I could spend the rest of our time together talking about the destruction of cultural sites, the destruction of other sites that are prohibited. And that's setting aside the issue of whether warfighters hide in or behind those to encourage the opposing enemy forces to destroy that and then claim they're the bad guys, which happens in all wars. And so I think the answer is yes, but unfortunately, the violation of that chews up the rule.
They're kind of land similarly, just by different routes.
I'm trying to be a little controversial.
Yeah, there you
so
go.
that so it looks sort of like a debate,
Yeah,
right?
you
Right.
know, it's a
But
discussion.
I think you and I are gonna agree on a lot of these things.
It's a lot's reasonably clear. on
Yeah.
that.
Our next question is, are the US and international community obligated to assist countries who are experiencing a civil war?
No. No, it doesn't mean it's not the right thing to do. And of course, the answer, of course, it depends again. And so, I mean, how many armed conflicts are happening around the world right now? Dozens, dozens and dozens. I bet you can't even name 5. I'd give you extra credit if you could name 10. Does that mean we as a sovereign country need to all of a sudden interject either kinetic force, military force, intelligence sharing, or other activities to assist one of the parties or both of the parties in the conflict? No. That said, you know, all countries act typically in their own best interest, right? I mean, what's good for Canada is good for Canada, doesn't necessarily mean it's good for Suriname, right? What's good for Australia is good for Australia, doesn't mean necessarily good for France. And it's not unique for a country to act in its own self-interest. And so when we take action, such as military operations other than war, or even going so far as to take kinetic action, we do it, hopefully, this is more of a theory than in practice, because it advances our own self-interest. But there are dozens of wars, maybe hundreds, depending on how you define it, going around the world, and we're not obligated to, nor should we, in my opinion, be poking our nose in those conflicts.
I mean, it's a dangerous thing to do.
Yep.
To the extent that you look at where a lot of what is currently plaguing international law went wrong, because people said, well, sauce for the goose is sauce for the gander, is the idea of the responsibility to protect and the unilateral use of force in order to intervene in civil wars. You can draw a direct line between Russia's justification of its invasion of Ukraine and NATO's action in Kosovo. So to the extent that you open that particular Pandora's box, you're really in for it. And so that's where I would say it really becomes incredibly dangerous to do this outside of collective action mechanisms like the UN Security Council. And even then it's dangerous.
Yeah, and I mean, if I could extend those comments, which I agree with, it tees up the question of Article 5, right? Remember, Article 5 isn't a self-licking ice cream cone. It doesn't automatically require a party to that particular convention to automatically jump to armed conflict. And in fact, because in the United States, if Article 5 is triggered, let's say in NATO, then it would be up to us to consider whether or not we would seek a authorization to use of military force or a declaration of war to go against the offending country. But it doesn't mean it automatically happens. And that's why these countries are sovereign jurisdictions, and that allows them to decide whether, if that article is triggered, they will then take the next step. That's different from saying we stand behind Article 5. Understand, as a diplomatic and legal matter, we're obligated under Article 5 to consider it, but it doesn't automatically mean we jump to it. I assume the professor agrees with that.
Well, so, at that point, they're not in a civil war context, I would assume.
Correct.
So in that context, you really have to look at what the consequences of this are, right? So one needs to be careful about what one wishes for. The thing that keeps me a little up at night is, to the extent that the security commitments of NATO member states are called into question by other member states, this will lead to rearmament in countries that one of them might come from, half German, half French, that I'm somewhat uncomfortable with. But you know, those are, German rearmament has rarely been good for the world. So.
I'm Hungarian. I feel your pain. Yes.
So, it's something where I would say, well, if you have credible security commitments, you make that less likely to happen. But these are all things where we need to look at not necessarily what the law requires of us, but how the law leads to predictable reactions and balancing these things in light of national interest.
Yeah, and so let me just make sure the audience, we're not talking past our colleagues here in the audience. Does everyone know what Article 5 requires? Does everyone know what the concept of collective self-defense means? Yes, okay, good.
What ethical obligations do countries have to refugees displaced by wars they were involved in?
I mean, I will fall into the trap. Say, let's not move their children forcibly to another place and give them the citizenship of that other place would be a good start, right? Let's see what Russia is doing. In terms of other obligations, it again depends on the circumstances. Part of the biggest issues that I think we're seeing playing out today are much more about trying to figure out how to minimize the need for displacement in the first place. If you can minimize the need for displacement, you're in a position that people are in a much better position to begin with. The moment that you have refugees, you start having a real difficulty. We see that politically as a destabilizing factor in all manner of places. At which point you would look at, asylum obligations, you'd look at the obligations that states have self-imposed in that context. Beyond that, it starts becoming something that is it becomes itself a destabilizing factor when it's to address. How one does so, I think, is really up to each state to figure out on its own.
So 3 words popped to mind when I heard that question and when I read it. Ethical, moral, and legal. And I think about those in 3 different buckets. And let's transport ourselves back in time to the 1940s, because it's a little easier to analyze that than thinking about Russia or Crimea or Palestine or something like that. What obligations did the United States and our allies have to rebuild Germany and help with displaced persons in Germany? What obligations, ethically or morally or legally, did we have to help with the Japanese people after we dropped the bombs in Hiroshima and Nagasaki? It's easier to think through that, I think, than it is to try to resolve the Sturm und Drang that's happening in today's conflicts. Legally, none. Arguably. Ethically, pretty strong case. Morally and ethically, there's a lot of Venn diagram crossover in moral and ethical obligations. But I'm reminded of something that Secretary Don Rumsfeld used to say to this close group of political appointees that worked for him, and I had the privilege of working for him. And he would say, "And what next?" Somebody would propose an idea and he'd say, "And then what?" And you'd give an answer and say, "And then what?" So let's say you don't do anything. And then what? Where does that leave those people's, your diplomacy, your moral walking stick on the world stage? Because you can't just walk away and expect that everything's going to be fine and the world's going to remain in the same place. And so I think, that's where diplomacy starts and war ends, and geopolitical considerations come into being.
One other thing that maybe I would add is states, of course, are free to limit their own actions in this regard. So you can have international conventions that deal with how many people one would take in, at which point one would have a treaty obligation to meet those commitments. But again, the treaty can be made unmade. So to the extent one then wishes to stop participating in that. Of course,
Right.
that keeps the state from saying, no, I can no longer.
Right.
Is there ever a moral justification for targeting infrastructure that indirectly harms civilians, such as power grids?
There ever, yes. Like the basic principles of the law of war would say, well, if you put the case sufficiently succinctly, there could be circumstances in which that's the case. It is one of the things that is the first casualty in most offensives. If you look at particularly the power side of this, it's not particularly effective. And it creates problems on the back end of the reconstruction problem. So I would say to the extent that you're looking at the question of, is a particular use of force targeting such infrastructure lawful? One might well get to the point of no, but one might also get to the point of yes. So that's always a factual intensive discussion. It will need to be done on a case-by-case basis. If you're asking, can it ever? The answer is yes, because there are circumstances in which that targeting is lawful. There are also circumstances in which it's unlawful. And then you again get to that bucket of, is that a good idea, even if you can lawfully strike it? And I would say, well, that's something where I would say, think twice about it. Consider in this context that, again, sauce for the goose is sauce for the gander. The media tend to make a lot of those strikes when it is a state we like less doing them, and forget that states we like more also act in reasonably similar terms. So one should measure with one ruler. Multiple.
Can you read that question again? Because there's an interesting aspect to the question I want people to hear.
Is there ever a moral justification for targeting infrastructure that indirectly harms civilians, such as power grids?
So I know Todd, St. John, I know Haley have been warfighters in our military. Anyone else serve in the military in a warfighting capacity? When you've been briefed, Haley and Todd, I'm not going to ask you to answer the question, but I'll answer it for you. Do you remember when you were briefed on the standing rules of engagement, anyone using the word moral? You're not equipped or qualified or trained to make moral judgments as a warfighter. That's for the divine or philosophers or professors or debates or law students. But when you get down to brass tacks, and you're flying the plane, when you're shooting the artillery, when you're taking the drone shot, you don't have a moral scale. That's amorphous. Is it lawful or is it not? Is it a lawful, legitimate target or is it not? If it's a legitimate target, and there are other considerations that come into play, you take the shot, all things being equal. If it's off bounds, but to the professor's point, there are other factors in there, such as the enemy secreting all sorts of, you name it, there, and they're violating the law of war by putting themselves in the mosque, putting themselves in the power station, putting themselves in there, conducting operations from there, conducting the operations from the church or the hospital. Again, go back 50 years. Let's not talk about the last 5 years. It makes it harder to think about. Then yes, legally, depending on the circumstances, you can make an exception based on those facts and circumstances to take kinetic action. Is it moral? That's for the Lord Almighty and philosophers to decide. Is it legal? That's where the war fighters have to decide. They don't sit there with this little blindfold woman who's the moral person, and you go up and down. It's not the way it works.
In regards to the rhetoric surrounding the US being a global military superpower, is it ethical to exert such military influence over other countries?
What do you mean by it?
I'm guessing the question is more like, is it ethical to not necessarily pick on someone your own size?
I mean, in some regard, it's flat out illegal. So to the extent that you're coercing a state in violation of norms of coercion, that would be violating territorial integrity, would be violating political self-determination in the states in question. And again, this is the US being the only superpower here is a little bit the problem of with the way the question is framed. We don't want anybody else doing it either. So on the legal side, there is some conduct that would be flat out prohibited. There is other conduct where influence to indicate to other states that no, we take these rules very seriously, and so we are going to act in a manner with our military to make sure that everybody understands that the freedom of navigation operations are things that are very good. So one again has to kind of look at like what is it that we're talking about in the freedom of navigation context, though. Now the Chinese are circumnavigating Australia, right, which is demonstrating blue water capability on the part of the People's Republic of China that is giving the Australians rather a hard wake-up call. So again, these rules are there for everybody, and so we should measure with one yardstick rather than two. So it depends on what you mean by the question, but I hope that answered it.
So in addition to what the professor said about what China is doing, they've also built in their island reclamation program, activity in the South China Sea, and the Spratlys have challenged the freedom of navigations of U.S. naval ships and other ships. But let me try to answer the question I think that's being asked. David, the Goliath question, big bad United States, is it okay to pick on a small country? What if Eritrea, a little tiny country in Africa, acquired the bomb and they had a deranged leader? By the way, I know a lot of Eritreans and I like them, play soccer with several of the guys, so I'm not picking on Eritrea, I'm just using this for exercise. And they have a deranged leader. And they say, unless you fill in the blank, we're going to detonate this bomb, and they name a major European city, or they have the capability of bringing it to the United States. All countries enjoy the inherent right of self-defense. It would be unethical for us not to do something about it if we thought that the capability existed. So I don't necessarily buy into the big country, little country thing. I do think, to Haley's point, and I know she feels this way because I've talked to her about being a Marine, that we have an obligation as the United States to adhere to the rule of law and the law of armed conflict wherever and everywhere we are. And that when we break those rules, and we do because we're filled with people who are fallible, we need to hold them accountable if they're found culpable. And we need to do that in a public and transparent way, consistent with the rules. And so I think that, for example, well, I'll stop there. Go ahead. Next question.
How should states be held accountable for supplying weapons to actors who commit war crimes?
Were you following the case before the Supreme Court in the last 2 weeks that tried to hold gun manufacturers liable for providing guns that ended up in the hands of cartels in Mexico? I think the answer is the same questions that even the 3 liberal justices are asking the advocates for Mexico. And that is, it's not illegal to produce military weapons. It's not illegal to sell them to other countries. If other countries then sell them to person A and they sell it to person B, and then ends up in somebody else's hands, it's not the country that's producing the weapons fault, unless there's scienter, unless they know by selling it, it's going to end up harming them. So I think that there's a causal chain here that it is assumed in the question, and I don't. I mean, we sell planes to Saudi Arabia, sell planes to all sorts of places. If that plane gets stolen by a member of ISIS and ISIS uses it for some horrible war crime, because of course that's all they're going to do, are we at fault? The company at fault for selling the plane in the first place? I don't think so.
The key thing would be how much exercise and direction of control is there
Right.
over the use of the armament. So to the extent there is, it becomes totally different ball, or yarn. To the extent that there isn't, well, it's, just that, it's sale of equipment. So
It's the same answer and problem I have with the gun debate. I mean, I was a homicide prosecutor, among other jobs I've had, and defended people when I was a defense attorney. Several of the cases I tried where people shot and tried to kill each other because they were a bad shot, they didn't kill them, or they did kill them with a gun. But other cases, they used hammers and knives. We're not banning hammers and knives. And there's actually a Second Amendment to cover hammers and knives. And so I have a hard time with that without more facts that would lead me to believe that there's a scienter, an actual connection between the production of that weapon, the sale of that weapon for that purpose to that actor. It goes back to first year torts, Paul's graph, right? Remember the Squibb case?
Should private military contractors like Wagner Group and Blackwater be held to the same legal standards as state militaries, and how could this be enforced?
how are you? It depends, and this time not as a company, it depends in what capacity they are there, right? I mean, to the extent that you're looking at members of regular armed forces, they receive legal protections under the law. To the extent that you're trying to say that these groups are acting in the same capacity, you need to provide evidence of that, and I would, have some doubts as to whether you'll meet your burden, but that would be the first step of that. If the question is getting at how should we regulate those kinds of groups, I mean, part of the problem that you have is that with one of those groups, at least, they are a group that, shall we say, maintains plausible deniability, at which point, for the sending state, at which point, to the extent that you want to maintain plausible deniability, then whatever actions are done by members of that group fall under normal criminal law, at which point they're regulated differently. But that kind of becomes the question of where do they fall on the spectrum? What is their role in the particular conflict? Are they engaged in, are they irregular forces? Are they sent somewhere else where they're not irregular forces, they're pure mercenary? I mean, these are all things that you'd need to kind of figure out in order to give a better answer to that. But onto that.
Unaccepted. Caveat, full disclosure, I was co-chair of the Hamdania and Haditha task forces during the Bush administration, and I advised a defense counsel in the Nasser Square shooting case, which charged Blackwater guards with the killing of civilians in Iraq in Nasser Square. So with those disclaimers out, and I'm not speaking on behalf of any of the parties I mentioned or the DoD. Congress has addressed this or attempted to address. They passed the Military Extraterritorial Jurisdiction Act, MIJA. Now, when Haley was on active duty, when Todd was on active duty, anyone on active duty, 30 days or more is subject to the Uniform Code of Military Justice, UCMJ. That's the criminal code for all military personnel. And by the way, it's in personam jurisdiction worldwide. We can reach out and touch anybody, anywhere, under the water, in the air, in space. We have claws into them because they serve for the military. That is not the case for Blackwater and civilians. And so because of Nasser Square, because of other things that have happened in prior wars, Congress attempted to extend essentially a long arm act, a long arm statute into zones outside the United States and hold people criminally accountable, to the professor's point, for actions they take in wartime as civilians or military, and be able to bring them into federal district court. And so Congress has seen that as a problem, hence the question. And is it perfectly satisfactory? No. Does it work all the time? No. Do sovereign governments, administrations use it all the time? No, they don't. But they've attempted to address that issue through MIJA.
How does the dissemination of propaganda and misinformation in this era of technology affect people's perception of conflicts? And do these perceptions affect the conflicts themselves in a dire way?
It happens all the time. It does. And I mean, what do you mean by propaganda is kind of the next question, right? Is the fact that somebody has a particular perspective on a conflict propaganda, it would be like the next kind of level of questions. In terms of, does it affect the conflict? Absolutely. Because people believe in narratives that guide policy that in turn affect the conflict. So it is very, very difficult to disentangle oneself from that. World War I is the perfect example of that particular dynamic. So to the extent you're looking at why World War I, how World War I began, it was because everybody, for reasons that made sense to them, saw the actions of everybody else as playing into their particular threat stereotype, which meant that the next action was, well, I got to escalate because they're escalating. When really what was going on behind the scenes is that a lot of people were trying to de-escalate and yet not communicating that to the point that everybody in the end stepped back from the brink of war. So if you take something that is 100 years plus ago now, you can see that a lot of the manner in which the reporting went about things and the perception about things went caused or was part of the causal matrix that brought on one of these conflicts. So this is something where I'd say, yeah, I mean, this happens all the time. There's really nothing you can do to regulate it because anything that you try to do to regulate it would end up making it worse. Certainly in today's information environment. And the antidote to that is humility and a lot of reading.
I have a movie recommendation for you. The Man Who Never Was. 1955 black and white movie. I'm sure you've seen it. I'm sure you've seen it. Deals with Operation Mincemeat. They've made a new version of it. It stinks. Watch the old version. And then if you feel the need to watch the new one, go ahead. If you're not interested in that, I encourage you to read a book about the Trojan War, the Trojan Horse. The deception operations and misinformation is part of warfare. It's been part of warfare since the Bible and before Jesus Christ. I think it's easy as millennials, whatever age group you guys are now. I don't know, I have kids in 20s and teens, so I can't remember what titles are for you guys anymore. I know I'm an old fogey, but you guys are the cool group. It's easy at your age to hear the word misinformation and go down a whole series of rabbit holes. You know, whether you're for the Twitter files or against the Twitter files, or for what Facebook was doing or against it, I don't really care. Again, divorce yourself from the last 20 years and go back to deception operations, which happens in wartime and in operations short of war. And so the fact that every warring faction, including the United States, engaged is in misinformation, disinformation, deception operations, deception campaigns, is just part of warfare. The fact that the internet makes it more viral and it can go quicker, the fact that AI now has really made things incredibly complicated and I think incredibly dangerous, because the degree to which the credibility and believability of the messenger, who may not actually be the messenger, saying this thing through AI, I think that's what I'd be worried about if I was you guys. I would be worried about the manipulation of AI that is so credible that it could lead a country to the brink of war. You know, is it hard to imagine? Because I know you guys, and I know you're not gonna admit it, but I know you guys scroll to the bottom of the internet some nights, find yourself 3 hours later going, what the hell have I done with my time? Because I've done it. And you watch the short videos and all the rest of it. Is it hard to imagine a really dastardly video that's fake, but looks incredibly real, of a world leader, Trump, Putin, pick your poison, saying nuclear bombs are leaving in 7 minutes. When Reagan said it, it was a joke, right? When Reagan, we all remember that. You and I, the three of us remember that. You probably remember it. It was meant to be a joke. Today, with AI, it could have incredibly dire consequences.
By the way, if you want to see a local point on deception warfare, go to English Term, right around the corner where you had a turning away of a potential invading force by precisely this kind of problem.
Interesting.
Okay, last question before we open it up, and just like be quick on this one, and only because you mentioned AI. In regards to AI-driven weaponry, who do you think holds legal and ethical responsibility for violations of laws of war?
It depends, and it's too hard to answer in 2 minutes. And it's a vigorous debate in the academic, intellectual, and military establishment right now. Same if you swapped out cyber versus AI. There's a big ongoing debate right now about that. I would encourage you to read Matt Waxman's scholarship. He's a professor at Columbia University. He clerked Supreme Court, was Condi Rice's national security aide on 9/11. He was the director of policy planning at the State Department. Brilliant guy. He's done a lot of good scholarship on that.
I mean, do we want to go down the rabbit hole?
We were gonna open it up to
Excellent, let's leave it there.
Yeah.
If you guys have any questions, we're gonna open it up until 6, so you can.
Mr. Sampson, thank you for your service. We don't get Navy SEALs over here to speak to us.
I was just a JAG, but I did serve with the SEALs, but appreciate it.
Civilian defense lawyer and 21 courts martial in Pensacola NAS. My second oldest son serves in the 82nd Airborne as a doctor, and my daughter serves as a cook for 7 years on the USS Harry S. Truman, and she's also a hand-to-hand combat instructor for the Marines. So the question I have, I'm somewhat biased towards the military. My question deals with something that happened in Guantanamo Bay. And the question deals with enhanced interrogation tactics. Some years ago, I wrote an article about enhanced interrogation, but I was focused really on the limitations of international law. So my name is David Katner. I run the juvenile law clinic here. I also teach trial advocacy, forensic psychiatry at the medical school, and evidence and 5 other things. My question with regard to enhanced interrogation is, we had 18 and 19-year-old kids in Guantanamo Bay who were being compelled to engage in interrogation tactics that, from many perspectives, were violative of international law. They clearly violated provisions of the Geneva Conventions, but they also violated provisions of the Uniform Code of Military Justice, which essentially is identical to the provisions of the Geneva Conventions. Despite what Pete Hegseth said in his inauguration testimony, where he was convinced of one and not convinced of the other, which makes no sense at all. Suggest he never read it. The issue, though, deals with international law. We have been completely unsuccessful at enforcing any provisions of international law that resulted from violations during the interrogations we engaged in at Guantanamo Bay. Should we focus on creating a mechanism of enforceability under international law provisions, or should we simply go back to the drawing board and conclude that what we engaged in was inappropriate? It's authorized, my understanding, as 2 civilian lawyers, one of whom is a tenured professor at Berkeley now, the other of whom sits in the 7th Circuit Court of Appeal. In my article, I suggested that both of them should be disbarred for having written what I call torture memos during the Bush administration. We've never held anyone accountable for the types of activities that we engaged in.
Sir, what is your question?
Should we even consider ethics conclusion, which would be disbarment, or should we consider rewriting international law so as to make it enforceable, so as to prevent such activities in the future?
Neither. Furthermore, you have your facts wrong, because facts do matter. And unfortunately for you, I conducted and implemented all 492 recommendations from the 12 major investigations across DoD for detainee abuses. And the 2 lawyers you're referring to, that he's referring to, are John Hewitt at Berkeley and Jay Bybee, who's on the 9th Circuit. DoD had 102,000 detainees in Iraq, Afghanistan, Gitmo combined. 75,000 in Iraq, 25,000 in Afghanistan, 779 in Gitmo. Today there's a couple, about a little more than a dozen at Gitmo and none in Iraq and Afghanistan. DoD had no policy whatsoever to engage in enhanced interrogation. There were 2 enhanced interrogations that took place at Guantanamo against 2 people early on, and that was fully investigated and they were reported. The enhanced interrogations that you're referring to didn't happen at Guantanamo Bay. It happened with the CIA. They had 119 detainees in their whole program. You can read Dianne Feinstein's RDI report, Rendition Detention Interrogation report.
I have.
And well, then you would know, or you've forgotten, that of those 119 detainees, 1/3 were subjected to enhanced interrogation techniques, and 3 were waterboarded. Those were CIA detainees, and it didn't happen at Gitmo. So facts do matter. Furthermore, John Yoo has not been disbarred. Dave Bybee has not been disbarred, and their bars took a look at it. So what extra jurisdictional or extra legal mechanism do you think when the liberal California bar does not disbar John Yoo, when the liberal bars are not disbarring Jay Bybee? What extra legal process do you think we should have? When, for
That's not
example,
an extra legal jurisdiction.
when,
That's-
for
that's an
example,
ethics
President
issue.
Obama, when he came to office, planned to close Gitmo in a year, failed. Planned to prosecute the people who waterboarded the 3 CI detainees, ordered John Durham, who was the sitting U.S. attorney for Connecticut, to investigate them and prosecute them. And John, after looking at it and looking at the torture statute, realized that they didn't meet the mens rea requirement for torture. So those people who did waterboard the 3 CI detainees weren't prosecuted. So what extra steps do you think need to be taken? Which I'm happy to talk to you after time's over, but I think that facts matter. You got some facts wrong. And I'm happy to talk to you more about other facts that you've stated in your question that are
I'm
wrong.
happy to respond to that, and I'll give you a copy of my article.
I'll be happy to read it. I may have already read it.
Yeah.
Does anybody else have any quick question? Russell wanted to.
Professor Sourgens, this was kind of inspired by something that I learned in your 1L class. So rest assured, you did a good job of teaching us. You remember some of the taught there. Specifically, it has to do in regards to United States tort law. We had our discussion about certain damages that you can receive for emotional distress, and the kind of sitting legal framework for it is that you have to be in the zone of danger, with the one exception of terror attacks. I believe sometimes if your family member dies in some overseas or domestic terror, then you don't have to be in that zone of danger and meet the test. And I guess it's really a two-part question. One is there any kind of framework in international law currently that provides redress for families that are impacted by terror attacks? And if there's not, should other countries and the United States kind of expand ways that victims of such attacks can find redress and improve?
So the way that some law firms have made rather a lot of progress in getting redress for victims is to sue in the United States. So you have a reasonably active bar of lawsuits for both state-sponsored and non-state sponsored terrorism that would use the US as a venue. By the time that the US normalizes relationships with states in question, typically those things get settled, which means they actually get paid. So to the extent you're looking at a place to or a mechanism to deal with that, the US is actually a pretty good one, at which point you avoid one of the main problems of international law, which is that to the extent that you want to have a dispute resolution body take jurisdiction, the respondent state needs to consent to that jurisdiction, which under those circumstances, they rarely would. So you're probably better off starting in the US for any process in the United States. There would be a foreign sovereign exact exception.
And the only thing I would add to that question, that answer, which I agree with 100%, is we do have the Foreign Claims Act and we do have the Federal Tort Claims Act. And I used to run the Federal Tort Claims division of JAG, and so we pay out claims all the time for actions taken. And then also on the Foreign Claims Act, we pay out small money amounts for torts by individuals or torts that US service members do against foreigners in foreign ports of call, which happen all the time.
This one is kind of broad, so you guys can kind of take it whichever way you guys want. What are your overall thoughts on universal jurisdiction and how that seems at the moment continuing to expand and so forth in the United States, not being necessarily a part of it, and the ICC? Kind of debate in general.
It sounds cool, right? It sounds like something that if you really feel like there is something wrong, and there's a really important principle, and we're trying to defend it, that one should look to universal jurisdiction. I think it gets you into trouble more than it gets you to solve the problem. Because again, sauce for the goose is sauce for the gander. So to the extent that you don't want people coming up with all manner of charges against people on a basis of a crime that falls under universal jurisdiction in an unfriendly place, it is best to restrain oneself here from making a similar invocation of universal jurisdiction, because once you open the door, anyone can walk through. So to the extent at looking at what works to protect the rule of law, in general, it is best that the places where the underlying actions occur, actually take charge of prosecuting people with regard to the underlying conduct. To the extent that that is politically non-tenable in that place, then having reconciliation commissions may be their next best bet to at least get the conduct on the record. To the extent that you locate those things extraterritorially, you're just looking for problems. So I would be, I understand the urge, and I understand why people say this is important, and so we need to defend it universally. I just see the dangers of it every day.
The only thing I would add is that I'll make a broad comment to your broad question and then a specific response. What's the limiting principle to universal jurisdiction? There is none.
No, from my knowledge, not much, which is
Correct.
why I don't really agree with it. And
Right.
I was just,
Right. No, but I'm saying just as a doctrinal matter for other people, I know you know the answer, otherwise you wouldn't ask the question. You're an almost lawyer. But it has no limiting principle. Or discernible limiting principle. And the best laws, of course, have limiting principles because that's how they're cabined and sustained over time. But to the professor's point, which is excellent, this is the reason why we haven't joined the International Criminal Court, because our body of law and numerous administrations, Republican and Democrat, have decided that our law is adequate to investigate and hold accountable wrongdoers in civilian military context, and we don't want to throw our soldiers, sailors, air marines, and Space Force types to the wolves when our laws are more than adequate to hold them accountable for misdeeds or crimes that they commit anywhere in the world.
The durability of international law. Suppose it was international law back in 1935, and then we had the worst conflict. I can't say it.
Conflagration.
In world history, 50 million people got killed. Has international law progressed since then? Such like something that couldn't happen. And then lately, it seems like there's all these, these flash fires all over the world, and then you see people like Hamas who are just beyond international law. Is international law, what's the future of it? Is it improved since World War II? And what does it look like?
I want to be mindful of your time because I know you have to.
Yeah,
at some point.
I mean, the main thing I would answer to that is that most international law is followed by most people most of the time. We have a significantly increased body of international law that is capable of at least providing means of engagement before you get to an escalation to something that would hit the national security level. To the extent that you're looking at where we are in terms of the teeth in international law today versus back then, I think we are in a much better spot. We will continue to be in a much better spot because we need these rules to work. And again, most of the time, most actors will abide by most of these rules voluntarily because they're in their own best interest.
Remember that the Geneva Conventions came into being in 1949 after World War II. And prior to World War II, there were conventions, but typically wars that were fought between opposing states oftentimes would have bilateral agreements of how they would deal with either civilians caught up in wartime or military members caught up in wartime or protected persons or places. And so after the conventions were signed and then ratified in their various countries over the years, including by the example, Afghanistan, you've had additional protocols, you've had other treaties, which are part of international law. And so I think that this ongoing and necessary discussion around the world as countries evolve, countries change, mores change, technology advances is crucial to a world order where there's a modicum of rules that we can all agree to. And yes, there are going to be outliers and terrorist organizations who, of course, don't care about any rules whatsoever except death and destruction. But we can't, and we haven't decided to change rules simply because there are non-state actors, and today non-state actors capable of global lethality. So, for example, after the attacks of 9/11, one of the questions, legal questions, was, okay, who are the high contracting parties to the Geneva Conventions? They look around. The attacks emanated from Afghanistan. Only 3 countries recognized the Taliban as the legitimate ruling party of Afghanistan. Yet Afghanistan had ratified the Geneva Conventions. And so does that mean that you give the captured Taliban person who is wearing his uniform, carrying his arms openly with a distinct rank insignia, prisoner of war status? And the answer was, by the dastardly John Yoo, yes. You do give him prisoner of war status, and that's exactly what we did. But for the people who were violating the law of war, who were the Taliban, no, because you fell out of the privilege. Now, Al-Qaeda, as a legal matter, wasn't a country, wasn't fighting for a country, so they were non-state actors, right? But it was decided, because they weren't privileged to be prisoners of war, legal status-wise, you still have to treat them with the bare necessities of Common Article 3 to the Geneva Conventions, which means you have to have a baseline standard of care and treatment, which the JAGs had been advising the warfighters in Afghanistan from the time we started picking up detainees in the middle of October 2001. But you don't turn international law upside down in norms because the outliers act outside the law of war and international law. You stick to your principles and you deal on a case-by-case basis with those extrajudicial, extra-legal exceptions to the norms.
What do people think in the world that all these legal constructs were formulated by Western imperialist countries, and that they shouldn't apply, or that they're being used to Western benefit, but the result is,
well, considering
people in the world are oppressed by it, and look, I don't subscribe to all this. I'm
No.
saying this
well, number one, I think it's poppycock.
Okay.
I think it's poppycock. I reject the presumption, the premise of the question. And secondly, if you look at the countries who have actually ratified the Geneva Conventions and others, they aren't, the colonial white countries. There are lots of countries around the world that have ratified the Geneva Conventions, and for good reasons, because it makes sense. It's in their best interest to join this universal set of principles and embedded with the doctrine of humanity, embedded in the Geneva Conventions and the additional protocols and others. Now, you can take reservations to this protocol or that protocol, and we haven't signed on to that protocol as a country, and we take exceptions to this thing. But in the main body of international law we subscribe to.
So you think it's durable and it should service the future?
Before I gotta pop out to my Uber, let me give you one example. The main international legal instrument that was used by states in the global north in order to resist the new international economic order are bilateral investment treaties. These bilateral investment treaties are in retreat between states in the global north and between global north and global south states today. We know where they're actually increasing between global south states with each other. So when you look at the principles that are coming out of international law, they tend to, when they work well, be used everywhere because they actually create predictability and they create a kind of stable environment that benefit everybody who participates in that benefit. So in the end, the idea to say that, well, because an idea came from a certain place, it's only going to help those people is shown to be wrong if you look at how international treaty practice works. International law helps everybody by keeping the rules of the game predictable, knowable, and even.
Thank you.
Yeah, I'd like to thank both of our speakers and everybody for coming out. Our next event will be April 8th over our speaker will be Clark Neely from the Cato Institute. We'll also have NOPD here and Professor Romero. They'll be speaking about use of force and police accountability. And then after that, we'll have April 10th, we'll have Athy Levis about the SCOTUS shadow docket.